And start with Mr. Stones. This is file 24-21836-FH, People versus Justin Lee Stonecipher. We are here today for sentencing. In this case, we are proceeding today by video conference. The courtroom is also open to the public. First, can I have the attorneys place their appearances on the record, beginning with Ms. McCree for the people.
Special Appointed Attorney General Elizabeth McCree, P76926.
Ron Underwood for Mr. Stonecipher this morning, Your Honor.
All right, the record should reflect that this matter was set for a sentencing hearing this morning at 8:15 a.m. It is now 8:20 a.m. Mr. Stonecipher is not present in person here in the courtroom, nor has he logged into the Zoom session. I would note I do have one device logged into the Zoom session labeled Samsung SM-S135DL. That person has not connected their audio, nor have they turned on their camera. I have sent several chat messages to that person instructing them to connect their audio, and I have sent several requests for that person to turn on their video. So at this point, I have no way of knowing who that person is. Ms. Underwood, is there anything you want to say with respect to Mr. Stonecipher at this point?
I have no knowledge as to Mr. Stonecipher's whereabouts, Your Honor.
Okay, I would also note that the file contains a memo from the probation department indicating that after Mr. Stonecipher pled guilty and was released on a PR bond, he failed to report to the probation office for his pre-sentence investigation interview. And he also failed to respond in any way to attempts by the probation department to contact him. And there's a request in that memo to remand him to custody so that a pre-sentence investigation interview can be completed. Given all of that and his failure to appear today, I am going to revoke and forfeit Mr. Stonecipher's bond. I'm going to issue a bench warrant for his arrest, and I will set bond on that bench warrant. Ms. McCree, do you happen to have the outstanding child support amount handy?
Yes, Your Honor, and I will just also note that there still has been no payment. The last payment was in 2019. Of course, it has signed me out. Just one moment, I have to sign back into the document here.
Okay.
The balance owed as of September 3rd, 2024 is $22,859.12. I would be requesting the statutory 25% be set as the bond amount in this case, especially since he was originally released on a PR bond after his plea and there has been no payment.
Okay, so 25% of that would be $5,714.78. So I will set bond on his bench warrant in that amount.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, thank you. And so, Ms. Underwood, do you need a breakout session with Mr. Blevens?
Yes, I do, Your Honor, but I have a question. Was there an update done on Mr. Blevens' PVR, Your Honor?
I do not have one, no.
Thank you.
And Ms. Heskey, let's see, she is not logged in at the moment.
Your Honor, I believe my business is concluded. May I be excused?
Yes, thank you very much, Ms. McCree.
Thank you. I always ask now because sometimes another hearing pops up. Nobody told me about. Thank you.
Yep. Ms. Underwood, I've set up that breakout session with Mr. Blevens.
Hey, Judge,
Yeah,
I have this down as a VOP arraignment, not a sentencing.
I'm sorry.
I have this down as a VLP arraignment, not a sentencing.
For Blevens?
Yeah,
All right, thank you.
No, he had been arraigned. This goes back to a failure to appear like back in January.
okay,
Okay, and so he pled to that back in April, and we gave him a PR bond, and then he failed to appear at the sentencing on that.
okay. On 8/21, I just put, on 8/21, I made a case note that says VOP arraignment held adjourned to 9/5. So this is the sentencing for that.
What was the view?
Morning. How are you?
Yeah. How you doing?
Good, how are you?
All right. Um.
Okay, yeah, so it's this, oh, sorry. right, we are on the record in file 23-21355-FC, People versus Nicholas Montgomery Blevens. We are here today for a couple of things. It's a sentencing on a violation of probation and contempt of court that Mr. Blevens pled guilty to back in April 2024, on April 23, 2024. After that, Mr. Blevens did not appear at the sentencing hearing. The court issued a bench warrant for that failure to appear. And Mr. Blevens pled not guilty to that second contempt of court for failing to appear at the probation violation sentencing. So first, let me have Ms. Underwood place your appearance on the record.
Ron Underwood for Mr. Blevins this morning, Your Honor.
All right, and Ms. Underwood, do you know how Mr. Blevens wants to proceed with respect to that second contempt of court that he had pled not guilty to?
Your Honor, I'm kind of, there's a lot going on here. And the first thing is, I suspect we've reviewed the PVR, and I suspect the recommendation in the PVR no longer applies. And we put this over, I believe, to try to get some idea of an update. Mr. Blevens, how do you wish to plead to failing to appear for your sentencing on the probation violation?
Guilty, I guess.
Okay.
Mr. Blevens, do you want to talk to Ms. Underwood in a breakout session again about that?
Yeah, because I'm not,
Okay.
All right. Okay, I have a Jail Zoom 5 device logged in right now. That camera is off and the device is muted. So if there's someone in the Jail Zoom 5 booth, I need to have you turn the camera on and unmute the microphone. All right, and sir, you're Mr. Gregory?
sir.
Mr. Millar, do you need a breakout session with Mr. Gregory?
Yeah, real brief, Judge, just like 5 minutes.
Okay, give me 1 second. All right, we have Ms. Underwood and Mr. Blevens back from the breakout session. Ms. Underwood, do you know how Mr. Blevens would like to proceed today?
He would like to plead guilty to that contempt, Your Honor.
Okay, Mr. Blevens, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury. I'm sorry, your device got muted somehow. I'm going to send you a request to unmute that device.
Yes.
All right, let's try it once more. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
And you are Nicholas Montgomery Blevens?
Yes.
Mr. Blevens, as we've discussed, the warrant that you were arrested on currently allege that you failed to appear for a sentencing hearing on a violation of probation in this matter back on May 13, 2024. Do you understand that the maximum penalty for a contempt of court is up to 93 days in jail or up to $7,500 in fines?
Yes.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes.
Do you understand that you have a right to contest the contempt of court charge and have a trial on it?
Yes.
Do you understand that throughout that trial, you'd be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yes.
You have a right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you also have the right to have me order any witnesses you have for your defense to appear at your trial. Do you understand all of that?
Yes.
You're not required to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes.
On the other hand, you also understand that you have the right to testify at the trial if you wanted to testify.
Yes.
How do you plead to the charge that you committed contempt of court by failing to appear at the sentencing hearing?
Guilty.
Do you understand that by pleading guilty, you're giving up any and all claims that I'm sorry. You understand by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained.
Yes.
Has anything been promised to you in order to get you to plead guilty?
No.
Have you been threatened in any way?
No.
If I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is it your own choice to plead guilty today?
Yes.
All right, so you had previously in this case pled guilty to a probation violation back in April of 2024. Is that correct?
Yes.
And we set a sentencing date on that probation violation for May 13, 2024. Is that correct?
Yes.
And you did not appear for your sentencing hearing here in court or on Zoom. Is that correct?
Yes.
I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Blevens has had full knowledge of his rights. He's had competent counsel. So now I suppose we would have sentencing on the two contempts as well as the probation violation. So Mr. Blevens, have you had an opportunity to read and review your pre-sentence report?
Yes.
Did you have an opportunity to discuss that with Ms. Underwood?
Yes.
Do you wish to explain or challenge the accuracy or relevancy of any of the information in your pre-sentence report?
No.
Ms. Underwood, before the court passes sentence, is there anything you want to say on behalf of Mr. Blevens?
Thank you.
Thank you, Your Honor. I am speaking without the benefit of a recent recommendation. So I will say, and I'm sure Ms. Teskey is aware, Mr. Blevens does have recent charges that he has a pretrial scheduled for on October 16th, I believe. With Mr. Murphy, I just wanted that clear to the court before sentence Mr. Blevens does want to get everything taken care of, Your Honor. I believe, obviously there's a substance abuse issue that does need to be addressed desperately, I think. And I'll just leave it at that.
All right, Mr. Blevins, is there anything you'd like to say on your own behalf before the court passes sentence?
No, sir.
All right, so Ms. Teskey, your original recommendation before the failure to appear was to continue Mr. Blevins on probation in the Lenawee County Recovery Court. Has that changed?
Yes, Your Honor. He absconded for over 60 days, so he's no longer eligible for drug court at this time on these charges.
Okay, and you're referring to the second time after he failed to appear at the sentencing hearing, is that correct?
That's correct, Your Honor.
Okay, so for the first probation violation that I'm dealing with now, that dealt with a failure to report on January 30th.
Your Honor, at this time, my recommendation, his guidelines are 5 to 23. He has displayed to the court that he is not taking probation seriously and continues to violate. Therefore, my recommendation would be continued on probation in order for him to complete SAI. Mr. Blevins, you've never been to boot camp, correct?
Yeah, I have.
You went to boot camp?
Yes.
Okay, so you're no longer eligible for that.
Your Honor, I do think if the court is considering some type of long-term incarceration on this specific item, and it in and of itself is a very garden variety failure to appear, that the court might want to wait until after resolution of Mr. Murphy's case in this matter, Your Honor. I think if we're just going to deal with this today, that perhaps what would be appropriate is a 15-day jail sentence and
So my issue is I don't think under the statute I can do anything more than the 15 days for a technical probation violation. So there was a warrant issued after he failed to report, alleging a technical probation violation for failing to report. That is what he pled guilty to, and so I think I'm limited by the statute that provides for specific maximum sentences with respect to technical probation violations. And since this is his first one, that would be 15 days. So with respect to the probation violation, it's going to be the sentence of the court that Mr. Blevins served 15 days with Lenawee County Jail. He has a total credit, I think, at this point of 21 days since his arrest. We'll give him credit for 21 days. with respect to the two contempt of courts for failing to appear at the original summons for the probation violation, as well as the failure to appear at sentencing. It's going to be the sentence of the court that Mr. Blevens served 93 days in the Lenawee County Jail, again with credit for the 21 days that he served, and that he be continued on probation. Mr. Blevens, you do have the ability to request an appeal of your sentence. We're going to send to you at the jail 3 copies of a notice of right to appellate review and request for appointment of attorney form. You'll need to sign 1 copy of that form, return it to the court. That just indicates that you got your copies of those forms. If you want to appeal your sentence, you need to fill out the remaining portion of the form and mail it to the address listed in the form within 42 days. Do you understand that?
Yes, sir.
All right, so you are all set for today. You can let the officer know that you're done with court.
Can I talk to Rhonda? Can I talk to you, Rhonda?
Mr. Blevins, I really have to get to my next. Is it a question about these cases?
Yeah, it'll
Okay,
be
go
fine.
on.
All right, give me just a second. I'll set that up. Okay, Mr. Malaro, are you ready to proceed with Mr. Gregory?
Yes, I am, Your Honor.
Okay, this is file 23-21584-FC, People versus Jonathan Andrew Gregory. We are here today for sentencing. In this case, we are proceeding today by video conference and also in person. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Arnold for the people.
Allison Arnold for the people.
Salvatore Malero on behalf of Jonathan Gregory.
All right, and sir, you are Jonathan Andrew Gregory, correct?
Yes, sir.
Mr. Gregory, have you had an opportunity to read and review your pre-sentence report?
I did.
Have you had an opportunity to discuss that report with Mr. Malaro?
Yes, I did.
Are you satisfied with Mr. Malaro and the advice that he's given you?
Yes.
Do you wish to explain or challenge the accuracy or the relevancy of any of the information that is in your pre-sentence report?
Judge, we are satisfied with the accuracy of the report.
All right, Ms. Arnold, do people have any issues with accuracy or relevancy of pre-sentence report?
No, thank you.
Mr. Malaro, does the pre-sentence report disclose any prior convictions in which there exist any known constitutional defects?
Not to my knowledge, Your Honor.
The probation officers calculated the minimum sentencing guidelines in this case to be from 29 to 57 months. Do you agree with that computation of guidelines?
No objection, Your Honor.
Ms. Arnold, do people agree with computation of guidelines?
We do.
All right, before the court passes sentence, then, Mr. Malero, is there anything you'd like to say on behalf of Mr. Gregory?
I think, Your Honor, this court is familiar with some of the facts of the case as it sat through conducted the first day of a trial. Mr. Gregory, as the report indicates, has a very minimal criminal history. All misdemeanors, these would be his first felonies. So I think that is something that weighs in his favor. He has the support of his family. His parents have been very engaged and involved in and for and on behalf of their son. I would only state, Judge, that notwithstanding of the nature of the offenses and that during the initial stages of this case, numerous people in the community contacted me regarding Mr. Gregory about his caring, helpful, and wanting to help others nature. It was rather surprising. I don't see that very often when I represent someone. So I think the recommendation is appropriate. The sentence agreement, I think, is appropriate given the facts and circumstances of this case, and I would ask that the court follow the recommendations as indicated in the probation report.
Mr. Gregory, is there anything you'd like to say on your own behalf before the court passes sentence?
No, sir.
Ms. Arnold, do the people wish to be heard?
Just briefly, Your Honor, I know the court heard testimony at trial about the injuries and the trauma, frankly, the victims suffered from this event. They're both lucky to be alive, but as Mr. Malaro points out, Mr. Gregory, this incident, I guess the motivation and why it happened is sort of a mystery to us all. Given the facts and circumstances, we would urge the court to follow the sentencing recommendation.
Thank you. In determining the appropriate sentence in the case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the report and recommendation of the probation department, as well as what's been said on the record here today. The criteria and reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to their commission, deterrence against repetition by you and by others, vindication for the law, and the protection of society. Mr. Gregory is 42 years old, and this is his first two felony convictions. He does have 5 prior misdemeanors. In this case, has pled guilty to 2 counts of assault with intent to do great bodily harm, less than murder. The court did hear a portion of the evidence in this case in terms of testimony that was given before the plea agreement was entered. The plea agreement does include a sentencing agreement for 36 to 120 months with the Michigan Department of Corrections. I do think that that is an appropriate sentence in this case. It is within the sentencing guidelines, and I think it does accurately reflect the very dangerous nature of what occurred here. There were people injured, and I think we're lucky that people were not more severely injured given the actions by Mr. Gregory. So again, I do think that the sentencing agreement, which is consistent with the recommendation, is appropriate. So I will follow that. It will be the sentence of the court that Mr. Gregory served 3 years with the Michigan, 3 years to 10 years with the Michigan Department of Corrections. He does have credit for 401 days served. You must pay a $130 crime victims assessment, a $60 DNA fee, and a $136 state cost. You do have, Mr. Gregory, the ability to request an appeal of your sentence. We're going to send to you at the jail 3 copies of a notice of right to appellate review and request for appointment of attorney form. When you get those forms, you need to sign one under the heading receipt of notice and return that to the court. That just indicates you got your copies of that form. If you want to appeal your sentence, you would need to fill out the remaining portion of that form and mail it to the address listed in the form within 42 days. Do you understand that?
Yes.
Okay. All right, then. We are all set for today. Mr. Gregory, you can let the officer that's with you know that you're, I'm sorry, you have a question?
I just had,
Actually,
go ahead.
Judge, may I, if I may, before Mr. Gregory says anything, that is 36 to 120 on both counts, correct, Judge?
Yes, that's correct.
And they are to run concurrent?
I'm sorry, yes, I did not say that, but they will run concurrently.
All right, thank you.
And then boot camp.
You have a question about boot camp?
Yeah, it was recommended in my PSI, so I was wondering if that means I'm pre-approved, or if you could pre-approve, or if I have to wait.
Judge, if I can address that, boot camp was initially recommended by Michigan Department of Corrections. I talked to Larry Patton about that recommendation, and they changed that recommendation to not recommend boot camp. We would vehemently oppose boot camp placement given the nature of events in this case.
All right, Ms. Teskey, is that accurate that the recommendation with respect to boot camp has changed?
Your Honor, it did not change on my end. If she spoke to Larry Patton, I mean, he could have.
Yes, an updated PSI was filed correcting the sentencing guidelines, which were wrong, and deleting the recommendation for placement in SAI boot camp. Mr. Patton filed that himself, sent us a copy, and sent the court an updated copy in August.
All right, generally what I do with boot camp and what I'm going to do here, because I think it's the appropriate course of action, is I wait until I'm contacted by the Michigan Department of Corrections. To my understanding, they do an evaluation once you've been transferred to their custody. And if they contact me and request an approval for boot camp, I will consider that request at that time.
Fair enough.
Thank you, Judge.
Yeah.
All right, thank you. All right, you're all set, Ms. Gregory.
Thank you.
Thank you, Your Honor. Have a good day.
Thank you. So,
Judge, am I done with you? You done with me?
yes, you also, let's see, oh no, yep, we're done.
Okay, do you need me?
Nope,
Okay. Thank you.
thank you, yep, have a nice day.
You too.